Right, good morning, everybody. Welcome to hearing stream number 14, which is entitled General Matters and Plan Integration. This is an auspicious day because it marks the last official hearing on the combined district plan for Wairarapa. But before we start, I think we'll all partake in the karakia to those that are online.
Mai te pai wonga, raro ki te tai. Mai te awa tonga, raro ki te awa raki. Tēnei e te hapuri, hapi ai tātai. Whano, whano, maere mā te toki. Umie, tai.
Thank you, everybody. Right, I don't know that it's necessary to introduce the panel.
I think we know each other.
I think we know each other, and the gallery is dominated by officers of the various councils.
Might be hundreds online watching.
It's 2 online at the moment. I'm going to hand directly to you, Morgan. I think you're going to take us through the summary statement on the general matters and plan integration. We're in your hands. A copy of your summary statement.
Thank you. So if it's possible, I'd like to start at section 2 and provide an overview of the general matters and plan integration.
Yes.
So this hearing stream addresses general matters that have not otherwise been addressed via the other hearing streams. In addition, it also addresses matters from earlier hearing streams that require integration across the whole proposed district plan. The general matters and plan integration hearing stream includes a response to David Ian McGuinness' submission point, consistency of wording related to water availability and efficiency, Radio New Zealand Limited's legal submission withdrawing aspects of their submission, an update to Rangatane Hapu list in the Tangata Whenua chapter, consolidated subdivision chapter with recommendations from previous hearing streams, integration of the interpretation chapter, and a response to minute 28 and other consequential amendments. Matters raised in submissions. A total of 1 original submission and no further submissions have not yet been evaluated through the previous hearings. This point relates to seeking consequential amendments to give effect to the relief sought in that submission. Pre-circulated expert evidence and legal submissions. There is no pre-circulated expert evidence or legal submissions relating to the general matters and plan integration hearing.
Morgan, just before you turn the page, on paragraph 6, the 1 original submission and that hasn't yet been evaluated, is that the McGuinness submission, or is it?
Yes.
It is.
Okay.
Yes, it's David Ian McGuinness submissions point.
Okay. Thank you.
That was my question.
Okay, moving to section 5, other matters. There have been general matters and plan integration matters that have been brought to my attention from reporting officers and the hearings panel that I would like to address. Key issue 1, hearing stream 1, whole plan integration of recommendations. Ms. Hooser, Ni Treadaway, advised that in the Section 42A report on the whole plan for hearing stream 1, it contained an evaluation and recommendation on plan-wide matters that amended each relevant chapter within the proposed district plan. These plan-wide recommendations were inclusion of common Māori words in the definitions chapter, and this includes iwi, hapu, whenua, tangata whenua, mana whenua, and tonga. Amend any reference to Treaty of Waitangi or Te Tiriti o Waitangi to Treaty of Waitangi, Te Tiriti o Waitangi. Retain definitions of Council's Engineering Development Standard and amend any reference to Council Engineering Development Standard to Council Engineering Development Standard 2023. Amend any reference to functional need and operational need to functional or operational need. This matter is not a new matter related to this hearing. However, as these recommendations relate to the proposed district plan as a whole and consistent wording, it is useful for the panel to be reminded of these matters.
Would you mind just pausing there and we'll see if there are any questions on that whole of plan integration topic? Am I right? Anything? Yeah.
No.
Okay. I've got one question, Morgan, and that relates to those 4 matters A to D and any other matters that might come out of the woodwork during our deliberations. Have those matters A to D already been captured in the track change version of the provisions, the blue and red lined provisions, or is the integration hearing an opportunity for that to occur?
So Ms. Hooser made the blue and red line track changes to her recommendation chapter that was appended to her report, but for where those ones that were made within the with the hearings post that hearing, they need to be made, and the general sweep up hearing that we're in today is a good opportunity to capture all of that.
Yes.
And we have done that in the background, so we can provide a copy of all the changes throughout the whole proposed plan to you.
Yes. That raises a little red flag for me in terms of version control of the provisions. The panel have been doing what will be known as the green line, which is their final recommendation or decision on provisions, which is essentially taking the red changes from the 42A and the blue changes from the summary statement and right of reply and deliberating on those and making decisions on the red and blue and confirming those through a new colour, which is green. The decisions that are issued will have the decision report and an appendix that includes track change provisions in green text, which will be the difference between the plan as notified and the decisions version. It won't have any other colours. The blue and green will be absorbed into, the blue and red will be absorbed into green where the changes are accepted by the panel. So the panel started doing that, and I'm just conscious that those changes in A to D that affect topics other than those that Ms. Hooster has drawn her mind to will need to be revisited in some form. It's something we can talk about offline if necessary because it's an administrative matter. But have either you or Mr. Horrell got any response to that?
Mr. Horrell, do you have any comments?
Yes. I guess if I understand the question right, the panel would like us to provide the confirmed versions of each chapter and clarify if there has been any changes from versions that you've been referring to, which would be the right of reply version of the chapter.
It would be a starting point, the right of reply version, and perhaps marking that up with any new changes, maybe through a shading or a green or yellow.
Not green.
No, but a highlighting rather than a colour.
That's right. Okay. Okay. No, we can do that. So highlight any of the changes, which would be A to D, and then any other consequential omissions that hadn't been captured.
Yes, thank you. It's largely a administrative matter, but version control is essential. Yeah.
No.
We've made a start on it already. Thank you.
Yes.
Issue 2.
So since the proposed district plan was notified, council officers have identified references in the to the operative plan that need to be amended, i.e. update to the equivalent proposed district plan reference. Designations relating to the Hood Aerodrome in Mania Road, so MDC M04B and C, are included in the designation chapter. There are associated conditions relating to these designations, including residential activities. On both designations, Condition 14 relates to new residential activities and acoustic requirements, and Condition 15 relates to new buildings obstacle limitation surface requirements. Both Conditions 14 and 15 on both of the designations reference the operative district plan provisions for acoustic requirements and obstacle limitation surface requirements. There are no submissions requesting the amendment of these references. As these requirements have been rolled over from the operative district plan into the proposed plan, there is the only change to the rule reference number. I consider these amendments can be made as a correction under clause 16, schedule 1 of the RMA. I recommend that the noise rule in both conditions 14 and 15 of MDC M04B and MDC M04C should be amended to noise R4. I recommend that the obstacle limitation surface requirement rule in both conditions 14 and 15 of MDC M04B and MDC M04C should be amended to TR R6.
Okay. I sat alone on this matter last Monday, so I'm the only one that will probably have a question. And I do have one question. Are we talking about the same rule content, but just different numbers?
It's the same rule content. It's an equivalent of what was in the operative plan going into the proposed plan. It is a change in the reference to the rule.
Okay. You're categorical that there's no content change whatsoever between the two rule references?
Yeah, it's just a change in the rule reference, not a change to the content.
Okay, that makes complete sense to me. Thank you. Issue 3. Oh, sorry. And again, that presumably be undertaken as part of the right of reply on the designations topic.
Yeah, yes, it could be done then. Yes.
Okay, thank you. Yep. Make a note of that. That would be good.
Okay, thank you. Moving on to key issue 3. The hearing panel issued minute 30 in relation to hearing stream 5, sites and areas of significance to Māori in respect of the submission from Kawakawa 1D2 Ahu Whenua Trust, who originally sought Puraraki, a traditional freshwater source, as a wahi tapu site. The panel directed Ahu Whenua Trust to provide response to matters raised in minute 30 so that the panel could consider this matter further at the hearing. The matters raised related to the following in A to C. And I'd like to update my summary statement as at the time of writing a response had not been received by the Trust, noting that the time frames were to provide a response by Monday at 4 p.m. But on Friday, after my summary statement had gone up online, a response has been received.
Yes, and if you could just pause there, panel, Ruth emailed that to us. It's a letter from Bryce Lyle.
Right.
There's the date. Has everyone seen that?
Yes.
Good. Okay. 2-page letter, and it was seeking confirmation of the panel's understanding of their current position. Do you have anything more to add on that, Morgan? It's not, was that your topic? That wasn't your topic in Sessions, was it?
I supported Mr. Wesley with this topic, but
Yeah,
I
so
don't have any further information or comment to add, just noting that the trust confirmed that that was the case as set out in the minute 30.
Okay. Are you in a position to take any questions on the panel on the substantive aspect of the topic?
I think it probably is appropriate that Mr. Wesley responds.
Okay, in that case, Mr. Horrell, panel will require an updated recommendation from Mr. Wesley on the inclusion or otherwise of that resource on the landward side of Mean High Water Springs. And whether his recommendation has changed in any way as a result of the correspondence that's occurred over the last 6 weeks.
Okay. And in addition to Mr. Wesley, is that direction also brought into his advisor?
Yes, absolutely. And that would be
Army. Yes.
Yes. Just before we leave this topic, does anyone have any questions or any particular matters that would like Harmy and Mr. Wesley to address in their response to this matter? Now's the opportunity to direct that. Okay, you go to page 2 of the letter from Mr. Lyle, you'll see the delineation of the area which extends into the coastal environment beyond the Mean High Water Springs, which is outside the district council's jurisdiction, but there is part of the resource that is between the road and the Mean High Water Springs. It's within the district council's jurisdiction, and that's the part that this is it Punaruku wetland is sought as Waihi Tapu site, I think as a SASM site, the proposed district plan.
Just one, I can't quite read the measurements on there. Are they measurements or are they just geographical?
No, they are measurements, I think, Brian.
Is it 67?
65.5 metres there and 120, is it?
Okay.
Yeah,
Then
So-
it's also got the degrees.
it's got the degrees too. So
Oh,
yeah,
yeah.
so roughly
I can see
65
that.
by 120 in the
And 67 down bottom.
So does that mean that it is obviously going to be Waihi Tapu, which is a no-go zone for divers in that area?
no.
We can't control
We
that.
can't.
We can't
The
control
blue
it.
hatched area is outside our jurisdiction, as I understand it. So it's the pink shaded area between the you see that Mean High Water Springs,
Yeah.
and between that and Cape Palliser Road.
Yeah.
Is the area that would be Waihi Tapu if that's the recommendation.
Oh, okay. So the shaded blue area.
Originally, the recommendation was that the entirety of the area was outside the council's jurisdiction, but it's since been determined that that's not the case.
Okay.
This plan indicates that it's split between 2 jurisdictions.
Yep.
And so we just need Mr. Wesley to update his recommendation.
And then it is the original submission for the wetland.
Yeah. I
Okay.
just think it would be pretty hard to control it.
That would have fallen in the polygon
Yeah.
presentation that Army to fighting.
That's dead right.
Yeah.
But yes, just to confirm, Mr. Horrell, Harmy Tafaidi's input into Mr. Wesley's response would be essential. And I know there's already been some offline correspondence between Mr. Tafaidi and the submitter in that sense. I don't think there'll be any surprises.
Okay.
Comes forward. Okay, thanks for your indulgence, Becky Morgan. Issue number 4, paragraph 18.
Yes, so there has been an omission of a recommended change to clause 2C of sub 12 subclause 2 in the joint witness statement dated the 3rd of February 2025, provided with a reply statement to hearing stream 6 in response to the coastal environment chapter. It should be noted for the record that this was an omission and is not inherently inferring that clause 2C is to be retained.
Okay, is that a change, or is there a change proposed?
My understanding is the change should show that clause 2C should be deleted,
Okay.
and that was just an omission from the joint witness statement.
Okay, I see what you mean. So it's a change to the subdivision chapter, not the coastal chapter. But it's it derived from the coastal chapter hearing, presumably, and involved a consequential change to the subdivision.
That's correct.
Yes, and you've usually provided an updated subdivision chapter in your right of reply, on your summary statement. Does that updated chapter address this omission?
I will just check.
It was appendix 2, I think.
That's the one. Just finding the right reference here. So
It might have been on your summary statement, was it? Yeah. It was on the 42A.
on the 42A report, it is
Yes, appendix 2.
appendix 2, sub rule 12. Clause 2, sorry, just scrolling down to clause 2C. Yes, so that's been captured there. C has been deleted in red, and I have a comment there saying a recommendation from hearing stream 6 overlays part 2 as a part of the section 42A report.
What page is that on the appendix?
Page 37 of 47.
Okay, it's the PDF number, isn't it?
Oh, yes, that's on the PDF number.
Okay, 37. Oh, yes, got it. Yes, it is page 36 of 47. Okay, and there's a comment there up to the side. I see with. Gotcha. Okay. Well, that's Mr. Horrell, that's one way of identifying those changes that we talked about earlier. Through comment boxes out to the side, but I think some sort of wash or highlight would be useful too. But knowing the source of the changes would be useful.
Okay, so would the panel like to have all changes indicated? So I guess section 42A reply minute responses as those comment boxes?
No, I think that just changes that have occurred post the ROR.
Okay.
So it's those A to D that we discussed earlier.
Yes.
And any other ones such as this one, and any others that are identified during over the next few moments. So it's quite a ring fence task. I wouldn't want you to have to go back and.
No, that's fine. I just wanted to clarify that with that one did refer to the right of reply. So
yeah.
No, that's good.
Okay. Issue 5.
So issue 5 is in response to minute 28 and other consequential amendments. It has become apparent to the panel that there is a lack of consistency in terminology used to describe areas and resources of relevance to the eco chapter. In particular, wording relating to Indigenous biodiversity. The panel sought relevant planning experts for the councils and other parties with submissions relevant to the application of these terms in the PDP to assist them with these matters in the integration hearing. No meetings have been conducted prior to the hearing. No evidence or correspondence has been received from any submitters on this matter. To provide greater confidence and clarity on the above matters to ensure that the proposed district plan is clear and can be consistently implemented in the future, I have reviewed the relevant chapters of the PDP that use terms relating to Indigenous biodiversity and have identified the commonly used yet different terms in Table 1 below. I have provided recommendations and the reasoning for these recommendations in the table below. Would you like to take the table as read or to work through that?
I'm happy to take the table as read, but again, the same situation, we're wishing to see this presumably blue changes, or I know that in some cases you've been using orange text, and more recently in relation to this report anyway, for changes. So, but just so that we can understand what the recommended wording is, and that it's come as part of the integration hearing. So maybe orange.
Okay. Yes, we can do that.
Panel need to give careful consideration to this terminology because we're the ones that raised the issue in the first instance in minute 28. So yeah, we just need to see how it lands on the ground in terms of those provisions. They're all eco provisions, aren't they? They don't go beyond any other chapter. Oh, sorry.
Yes, they do.
Yes.
There are a few other chapters relating to energy, subdivision, coastal environment. Yeah.
Okay. So I think use of orange text for those, and all of those factors, Mr. Horrell, would be the way to go.
Okay. Were there any other questions before I move on to section 6?
Just one question. In terms of minute 28, there was a response from, I think, Mr. Wisney to that.
Yes.
And a response from Meridian, I believe, an email. We confirmed that there were no other responses received.
There were no other responses that I received.
Okay, right. That matter, and the time for those responses is now closed. So that matter is now closed and it's in the hands of the panel. Thank you.
Can I clarify that the Meridian wants a joint response with Genesis?
And if you heard that, the Meridian response from Mr. Fairbairn, I think, was a joint response on behalf of both Genesis Energy and Meridian Energy.
Okay, thank you for clarifying that.
Okay, section 6.
So the recommended amendments in response to the general matters and plan integration are shown in the table 1 above. And then moving on to section 7, the key matters in contention on general matters and plan integration are those key matters outlined in A to G below.
Okay. Now, we need any questions on the summary statement? Morgan? Okay. Before we let you go, Morgan, can we just, for completeness, go back to the 42A report? And let's just work through that to make sure we haven't missed anything. It'll also be our last opportunity. I'm starting at page 9, issue 1, which is the Mr. McGuinness issue. So that's something that's been dealt with. Issue 2 is the consistency of wording, and this is where I saw the orange text. So that's a good colour to use for the integration. The change to the CCR 04 recommendation and the GRZ policy, which replaces water resilience with water availability and efficiency. Can you just remind the panel of the origins of that?
So that came about during hearing stream 1, which was the strategic direction in general matters. Mr. Wisney made that recommendation to change the CCR 04 water resilience and replace it with availability and efficiency for clarity. There was then, yeah, that's where it originated from.
Okay, thank you for that. So what the panel will expect then is the version of the strategic objectives with the red and blue and the red and the orange added into that as part of the right of reply.
Okay, I can do that.
Thank you. We just really want all those changes in one place, and backfilling the right of reply version is the way to go. Okay, so that's the explanation that follows. The Radio New Zealand withdrawal of aspects of their submission. What's the net result of that change? Is it solely the change to the matter of discretion? It's in the GIZ standard 1, clause 6, page 14 and 15.
Paragraph 16.
Paragraph 60 there. So Radio New Zealand withdrew aspects of their submission, and that related to the specific height controls and safety risks near their facility. But the rest of their submission, more broadly to the proposed district plan, remains. And that part that they withdrew related to standard 1 in the general industrial zone, and a standard in the general rural zone, as well as an advice note within that general rural zone.
Okay, I'm only seeing the change to the GIZ zone in your appendix 1, page 15. I'm not seeing the change to the general rural zone chapter GRUZ standard 1.
I believe the change was to reflect the GRZ standard, so
Okay.
I guess no change was necessary to that standard, given it was to reflect that in the industrial zone. My understanding it was more just to remove direct reference to the Wainawa infrastructure, given
Yes.
that indicated that that's no longer going to be in use. So just making a general direction, just to make sure it's not unclear to plan users.
Yeah, no, I understand that, Mr. Horrell. So had there been is the change to the industrial zone standard just something that was missed and is now being addressed?
So there was going to be a change in response to the submission. So we'd identified that inconsistency between the zones. So we were going to be making a change regardless, but with their withdrawal, we ended up, I don't have it in front of me, but I think some of the changes they'd sought we're no longer making, given they've withdrawn their submission, but this remaining matter of consistency, we've said, well, actually that's still necessary.
Okay.
But that can be a Schedule 16, Clause 16 matter, as opposed to responding to a submission.
Yes. No, I understand. I understand the broadening of the matter of discretion away from specifically dealing with the facility that they no longer operate at Waingawa. So just for completeness, has there been a change recommended to the GRUZ, or is that now redundant because of the withdrawal of the submission?
That is now redundant due to
Okay.
the withdrawal.
Yep. And has that been captured, that non-change, has that been captured in the right of reply in the rural zone?
No, it won't have been, given, well, the change to respond to the submission would have been, but I guess with this withdrawal, we will need to remove
Yes.
those changes.
Thank you. Yep. And maybe again, just show them as orange in that rural zone. It's an integration issue. Yes.
Okay.
Okay. Okay. The 5.7 was the consolidated updated subdivision chapter, which we've already talked to, which is Appendix 2 of the restatement. Thank you for providing that. And the last matter was the various definitions of customer connection. What else was there? Maintenance and repair.
Yes, as well as upgrade.
Yes, upgrade, which. Right. So have those changes been made to the network utilities chapter? Right of reply version. Again, it's the same thing, just making sure that these changes are shown in the updated right of reply version for the network utility chapter or any other chapter that's affected.
Yes, we can check that.
Yep. Okay, and that's everything from me.
There was just one other that we skipped over. There was key issue 4, the Tangata Whenua chapter, and updating the Rangatane Hapu list.
Yes.
Just making sure that you didn't have any questions on that matter.
Sorry, that was the bottom of page 11, wasn't it? Yes.
Bottom of, yeah.
Any questions on those changes, Joe or Kieran? No. Doing that as a clause 16 matter, are you? Or is it within the scope of the submission?
I think it's within the scope of the submission. They had mentioned there was an error after the submission. So what I've recommended is that the updated version is added into it for completeness and consistency.
Okay. Thank you. I've got one question that's not related to the summary statement of the 42A report. Relates to the hazard right to apply. I can't recall who the author on that was. Might have been Mr. Wesney.
Bronte.
Mr. Lincoln, Bronte Lincoln.
Okay, Bronte, right. It concerns paragraph 8 of the right of reply.
I'll just find a copy of that.
The key message in that right of reply is that there's no scope to include the Greater Wellington Regional Council request to include visitor accommodation in the list of hazard sensitive activities. And my question is, what category does it fit in? Does it simply become a less hazard sensitive activity by default? You might not be able to, you might want to put that question to to Bronte and cover it in the right of reply.
I think that's the most efficient way of doing that. I'll have a discussion with Bronte and include that in the right of reply.
Yes, you captured the question, okay?
What was the paragraph?
It starts at paragraph 8, I understand.
Paragraph 8.
That has an ROR, I just don't have it in front of me. I wrote it down last night. Yes, that's the beginning of it. Greater Wellington are requested that visitor accommodation be included in hazard of sensitive activities. It's been determined that they didn't have scope to request that. And that's probably not up for debate. Just a question of what category does it fit in, and does it default to less hazard sensitive activities? Which I think probably it does, but we just need to have that confirmed or completed. Yep. Okay. Mr. Harold, the last matter is, and you don't need to do it now, but we just need an update on the outstanding responses on any conferencing or outstanding minutes.
Yes.
Are you able to give a verbal indication of that now, or would you prefer to do that in offline?
I may need to confirm offline, but I can indicate what my understanding is. So at this stage, the natural hazards, we're waiting on the joint witness statement between Brookside Developments and Greater Wellington, and
Yes.
following that, a reply from the reporting officer. It may actually, for efficiencies, be we could have the reporting officer also respond to that matter that you've just raised.
Yes,
If that's your preference.
Yes, that's perfect. Can you just remind us what the timeframes for the JWS and the ROR on that side matter?
Yes, one moment. So the joint witness statement is due on the 30th of May,
Yes.
which is the end of this week, and then the officer's reply following that will be the 6th of June, so 5 working days after.
Thank you. I understand that there's also some outstanding work on the Jew Brothers submission, which is the rezoning matter at Wood Aerodrome.
Yes, that's right. So for the rezoning hearing, the timeframes we currently have. So the joint witness statement is due on the 9th of June between the Jews Brothers and Marston District Council reporting officer. Sorry, the 5th of June for that. No, apologies. I'm getting them around the wrong way. It is the 9th of June for the joint witness statement. The reply statements are due on the 5th of June, which is the Thursday prior to that.
Yes, so that's the reply on everything other than Hood, isn't it? That's the reply statement on rezonings, with the exception of Hood, presumably.
Yes, that's right.
Yeah. Okay. Now, I don't think the panel set a reply date, unless because it may not be necessary for following the joint witnessing, but we'll reflect on that.
Yes. So at this stage, the Marston District Council reporting officer would be providing a response to all matters except for the Jews Brothers
Yes.
submission. If there is mutual agreement, it may be provided through the joint witness statement, but if not, you may wish to have further direction from the reporting officer.
Yes. I'm just going off memory, being imperfect. The Lafferty submission, is that subject to any further information?
That was you had directed the submitter provide further information, which they have.
Yes.
So that was confirming some of those rules
Mr.
that would apply.
Mr. McDonnell?
That's right, yes. So that has been provided. And at this stage, the direction had been for the reporting officer to confer if necessary and conference. I guess as I'm the reporting officer, I can probably update that I don't anticipate I'll need to conference with Mr. McDonnell, and that response did further clarify some of my questions.
Yes, so you'll cover that on the ROR on the 5th of June.
That's right.
Okay. It was the Masters and Motor Lodge matter. Just can't think of the submitter's name.
Is the quest.
ET Quest.
ET Quest. Yes,
Yeah.
so that information was also provided.
Yeah.
When was that provided? I think that might have been last week. It was
That was on
provided
the
to the
22nd of May, 11:35.
It's come in through a series of
Emails.
disparate emails. I think we would appreciate having that consolidated in some form because
Yeah,
there's a risk that that information might get lost. So if that's something you could work through with the hearings administrator and maybe just get it consolidated, see it posted on the webpage and
Okay.
distribute it to the panel. I just was fearful that we may lose those responses because they're not on the webpage. Okay.
Okay. Great. And then the minute 30, which was the Ahu Whenua Trust, has now been responded to, and you've clarified you do not need, actually, sorry, that was 28, but that will be further responded to by the reporting officer, which I've captured in a question. And then the last direction is following the designations hearing last week,
Yes.
with the timeframes of so 30 May for the reply statement for the non-territorial authority designations, which is the end of this week. There wasn't, as I understand, there was no remaining matters in contention, so it shouldn't be too much to come for that.
Yes.
The 6th of June is when the requiring authorities for South Wairarapa District Council and Masterton District Council are required to respond to direction from the panel.
Yes.
That was to further clarify the Paynes Farm and the Riverside wastewater
Riversdale.
disposal
Yes.
areas. Riversdale,
Yes.
sorry, yes.
Thank you.
And then the 13th of June is for any comments to be received from submitters following that information from the requiring authorities. And there would in particular be those submitters who are affected by those designations.
Yes.
And then finally, the 23rd of June is the reply statement for the territorial authority requiring authorities.
Thank you. Okay, that's very good. Thank you for that. Any final questions, panel? No? Okay. That's everything, I believe. Thank you for your summary statement, Morgan, and thank you both for responding on the hoof to those matters towards the end of the hearing. That's much appreciated. And please pass on thanks to your colleagues for their sterling efforts over the last year on reporting that. Certainly much appreciated by the panel. So thank you, everybody. The hearing is going to be closed after we recite the closing karakia.
yeah, Pakaria, Titaku, Tia, Ki Whakataha, Ki Whakataha, Tai,
Thank you, everyone. Hearing adjourned.
closed.